Welcome to our deep dive into why decades-old divorce decrees still matter today. First, we will set the stage with the core problem. Modern agencies require explicit proof of the termination of each prior marriage, even when later marriages took place. Next, we will explore the burden of proof and the risks of relying on officer discretion. Then, we will lay out practical, step-by-step strategies to document good faith efforts and assemble strong secondary evidence when records are missing. Finally, we will summarize key takeaways and test your knowledge with quick quizzes. Here is our agenda. First, we will explain why your old decrees are still critical. Second, we will contrast the burden of proof with officer discretion. Third, we will walk through the actions to take if your document is missing. Fourth, we will detail strong secondary evidence options. We will check your understanding with quizzes. Finally, we will wrap up with key takeaways and next steps. Before we proceed, this is an educational overview and not legal advice. Laws and evidence standards vary by jurisdiction and agency. Therefore, consult a qualified attorney for personalized guidance. This section explains the need for an explicit, unbroken chain of proof that each prior marriage was legally terminated. Although subsequent marriages suggest the earlier marriage ended, agencies cannot rely on that inference. Instead, they require primary documents, like a certified divorce decree or a death certificate, to verify termination. The flowchart highlights how the divorce decree connects your first marriage to later, valid marriages, forming a continuous, verifiable chain. Without the hinge document, the chain appears broken to the reviewing authority. This timeline visualizes key milestones from the first marriage through subsequent marriages. It emphasizes the divorce decree as the critical hinge event that validates the second marriage license. Primary evidence is expected at the divorce decree stage. If that document is missing, secondary evidence can supplement but does not replace primary proof unless the agency accepts it under its specific policies. The timeline helps you see where to focus your retrieval and documentation efforts. We contrast common myths with the legal reality. First, a current marriage does not inherently prove the termination of all prior marriages. Primary evidence is required. Second, a prior clerk's approval does not replace the reviewing officer's current obligation to independently verify. Third, missing records demand thorough documentation of search efforts, plus credible secondary evidence. Fourth, officer discretion is unpredictable and should be a last resort, not a plan. Here we distinguish burden of proof from discretion. The applicant bears the responsibility to produce primary evidence where possible. The reviewing officer cannot rely on assumptions or prior approvals, and must independently verify. If the document is missing, you should present evidence of extensive retrieval efforts and credible secondary documentation. The goal is to reduce reliance on officer discretion, which is uncertain and risky. This table organizes evidence types by strength and purpose. Primary evidence includes certified divorce decrees and death certificates, providing the strongest proof. Secondary evidence includes documents like second marriage license applications referencing the first divorce, docket numbers, or court index entries that corroborate details. Tertiary or contextual evidence includes statutes, policy citations, affidavits, and proof of searches. Process proof outlines your good faith efforts and becomes essential when the primary document cannot be obtained. Follow these steps when a TOPM document is missing. First, log every retrieval attempt and keep all correspondence and receipts. Second, obtain the second marriage license application and highlight any references to the first divorce, including court name, date, and case number. Third, gather ancillary court records, such as docket indexes or minute entries. Fourth, add contextual legal materials like the state's anti-polygamy statutes and relevant agency guidance. Fifth, package everything in a chronological exhibit set and include a cover letter that summarizes your good faith efforts and findings. Transitioning next, we will detail powerful secondary evidence options. This section lists strong secondary evidence options. Start with the second marriage license application, which commonly references the prior divorce details. Add court index entries, docket abstracts, or a certified index if the actual decree image is unavailable. Include affidavits describing the prior divorce and documenting your search efforts. Provide proof of communications and payments for record searches. Finally, Include legal context by citing state anti-polygamy statutes and relevant licensing rules that prohibit polygamy and require verification. As a bonus, we included a short markdown example for your cover letter introduction. Next, we will reinforce learning with a quick quiz. Quiz question. Which of the options is primary evidence of the termination of a prior marriage? Option A is a certified divorce decree. Option B is a sworn affidavit. Option C is the second marriage license application. Option D is officer discretion. You may pause the video now to think about the answer. We will discuss the answer in the next section of the video. The correct answer is A. A certified divorce decree is primary evidence. Affidavits and second marriage license applications are secondary forms of evidence that corroborate but do not substitute for the primary document when it is available. Quiz question. The courthouse cannot produce the decree due to archival loss. Which next step is best? Option A is to do nothing and resubmit. Option B is to fabricate a decree. Option C is to document good faith efforts and submit strong secondary evidence with a cover letter. Option D is to argue that later marriages alone prove termination. You may pause the video now to think about the answer. We will discuss the answer in the next section of the video. The correct answer is C. You should thoroughly document your retrieval attempts and submit robust secondary evidence, including references from the second marriage application, docket indexes, and official refusals. This approach reduces reliance on officer discretion and demonstrates diligence. This flowchart depicts the reviewer's decision pathway. If the certified primary document exists, the path is straightforward. Submit and expect routine verification. If it does not exist, the applicant must document search efforts, gather secondary evidence, and package the submission with a cover letter and exhibits. The officer then reviews. If the evidence is sufficient, approval is possible. Otherwise, the officer may issue a request for evidence or deny the application. This visualization helps you anticipate outcomes and plan the strongest route. These are the core takeaways. First, always prioritize primary documents. Second, prove your diligence with thorough documentation of all search efforts. Third, add robust secondary evidence that corroborates the termination. Fourth, include legal context such as anti-polygamy statutes and agency rules. Finally, reduce reliance on officer discretion by over-documenting your file. To summarize, old divorce decrees matter because agencies must verify termination of prior marriages using primary evidence, not assumptions. Later marriages alone are insufficient. When the decree is missing, document your efforts and present strong secondary evidence. A clear, well-organized packet reduces reliance on discretion and improves your chances of a favorable outcome. Next, we will close with a call to action. Thank you for watching. If you found this valuable, please like, share, and subscribe. In the comments, tell us your biggest challenge retrieving old records so we can address it in future videos. See you next time.